I'm excited. I'm excited like a motherfucker, y'all. I have cracked the code. I have officially cracked the code. I've been talking about the presumption of death all year. And what I've come to learn is that, see, I went to probate court thinking that I was going to file a petition to rebut the presumption of death. And I'm thinking that that's what I had to do, but that was really talking about someone who's actually presumed dead, in error for real, like real death. However, here in Georgia, they say you're missing if you're after 4 years. The Cestui Que Vie Act of 1666. Here in Georgia, after 4 years, you're presumed dead. But they say they refer to you as missing, but the presumption of death takes effect after 4 years. In other states, it's 5 years, and in other states, it's 7 years. It's just different depending on what state it is. If you type in presumption of death in your state, you'll find out how many years. You type in presumption of death followed by the name of your state, you'll find out exactly how many years you're presumed, after how many years goes by until you're presumed dead in your state. Then they go to presumption of death. However, I was thinking that there was an order put in place at first. That was his first thought. I wasn't sure about it, so I had to test it by going to probate court with a petition ready to file it to open up a case in probate court. Couldn't do that. They wouldn't file it. They said, we don't just file, random petitions like that. Do somebody, claiming you're dead? Do you have a death certificate or something like that? And I didn't have evidence of that. So I had to go back to the drawing board. I'm like, okay, I just walked on out of there. I'm like, I wasn't discouraged. It was a learning experience. It was an experiment. So I did that. So I'm like, cool. They don't have an order put in place. They don't file these petitions. So you can't just go before, do that in probate court like you do in superior court. Just file a petition or something like that. So I was talking to a guy earlier today about, just seeing you talking about how he's supposed to have some settlement money coming in for some particular settlement or whatever. And he's on child support. And I'm like, and he talking to these child support people on the phone or whatever, however he was communicating with him. I don't like when I'm talking to people, but I don't advise people to talk to people on the phone. But he worried about his money being taken because, this child support and them taking his settlement money and all this stuff. And I'm like, how the fuck they get that kind of power to just take your money from you? No matter what you get, they can just bully and take your money like that. I'm like, they must got a power of attorney or something in place like that. Something got to be like that. It caused me to start researching, and I learned the state has a power of attorney on it. The state has a power of attorney over your estate, and it's because of that presumption of death. It goes into effect after you're presumed dead, and you have to revoke that power of attorney. I'm going to prove that to you. Stay tuned. Here we go. I'm going to show you what I'm talking about, y'all. Okay, y'all remember me talking about the presumption of death months back. I'm not going to go through the whole thing, whole process all over again. Go back and look at my previous videos. I went through multiple states. I went through this from top to bottom, so I don't want to go through that, but I want to bring something up, because I'm bringing it full circle. Okay? This is the key words. I want you to remember this. When you're talking about the presumption of death, remember the Cestui Que Vie Act of 1666. All 50 states do this. Even if you type in presumption of death, Social Security Administration, they have a code in there. Even in their manual, they do the presumption of death too. All of them do that. Then the base number is 7 years. After 7 years, you've been missing or absent. You're gonna be presumed dead. That's what they call missing or absent. They haven't heard from you. They have no proof that you're still alive. After 7 years, you're presumed dead. Now, here in Georgia, it's 4 years. In Florida, it's 5 years. In some other states, like say California, it's 7 years. So you got to look in your state, type in presumption of death followed by the name of your state, and you'll see that the presumption of death occurs at a certain period of time after you were born. Keep in mind now, if it takes place after 4 years here in Georgia, that means I was presumed dead. That's the presumption when I was only 4 years old. Now let's read, proving what I'm talking about. A domiciliary of this state who has been missing. That's the key word, missing. Okay, from the last known place of domicile for a continuous period of 4 years shall be presumed have died, provided, however, that such presumption of death may be rebutted by proof. The date of death is presumed to be ended, to be the end of the 4 year period, unless it is proved by the preponderance of evidence that the death occurred earlier. But after 4 years, you're gonna be presumed dead. Okay, that's what they do. Okay, just hey, look here. That's what preponderance of evidence. So anyway, now keep in mind, I'm gonna take you back here. Let me back up at 4, so you understand issues of letter. Keep this in mind when you see the issuance of letters. Okay, they talk about letters of administration and letters of testamentary. Okay, now let's read this. At any time after entering the orders, I'm gonna pause for a second because I skipped 1 through 3. If you go back and look at these codes, 2 and 3. Let's see. 1 was what I just read. 53-9-1 is what I just read. 53-9-2 and 3 I did not read. That's what they were talking about, going through the looking for you and all this other stuff that's extended looking for you or whatever. That period. At any time after entering of an order, entering of the order, finding a missing individual, keyword again, to be dead, a probate court shall issue letters of administration or letters testamentary, or an order granting years support, or an order that no administration is necessary, in conformity with all of the requirements of the appropriate laws of this state on the estate of the missing individual, and such letters or order, unless revoked, and all acts done in pursuance thereof and in reliance on such letters or orders shall be valid as if the missing individual were known to be dead. Okay, so they're gonna be operating as if you are dead. Okay, until you're proven to be alive. Y'all been hearing this across the internet for a good minute now. We're in the information age now, so it's not hidden knowledge. It's not hidden information. Okay, now I'm gonna move forward. I'm done with talking about. So you understand, here in Georgia, it speaks about missing persons, and say you ain't got to be dead. It say if you were known to be dead, that's how they're gonna operate, as if you were known to be dead. Okay, now I want to move forward. Now we're going to talk about the power of attorney. Okay, I want to talk about the power of attorney. Okay, let me see. When the power of attorney goes, when the power of attorney is effective, a power of attorney shall be effective when executed, unless the principal. I should have started with the instructions, not the instructions, but the the definitions. That was 9 I just clicked on, right? There, I believe. 9 right there, okay. Definitions. Okay? You always want to read your definitions anytime you go into a title, whether it's USC or your state statutes or whatever. Always be willing to read the definitions of all your stuff, so you understand what they're saying, what they mean when they say these things. When they use the terms they use, just like I showed y'all in previous videos with United States as an example. United States in one code says it's a federal corporation, and in another code it says it's a demographical, in a geographical sense. It's talking about a geographical sense. So it's talking about land, the actual place. So it's different definitions, different terms have different definitions. You got to always make sure you read the definition to understand, to get the full context of what it's saying. Okay, as used in this chapter, the term agent means a person granted authority to act in the place of an individual, rather denominated by such term, attorney in fact or otherwise. Such term include a co-agent, successor agent, and a person to which authority is delegated. So let you know that could be a number of people. It's not just one person. It could be people right in here. Durable means It means not terminated by a person's incapacity. That's a key word. We're going to look at the definition of that in a second. Okay. Now, electronic means relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capacities. Gift means a transfer of property for less than adequate consideration in money or money's worth that is not a renunciation within the meaning of code section 53-1-20. Good faith means honesty in fact. Okay, incapacity, this is the key word, the reason why I really wanted to go into this. Incapacity, they're going to use this a lot, and I want y'all to make you see that word I'm highlighting right here in my own mind right there. You just read that in the definitions in what it was talking about with the presumption of death. Anyway, incapacity, meaning inability of an individual to manage property or business affairs because the individual A has an impairment in the ability to receive and evaluate information or make or communicate decisions, even with the use of technological logical assistance, or is missing, detained, including incarcerated or in the penal system or outside the United States and unable to return. I want to pause for a second before I go to person. Keep in mind, this was your status right here when you were born, when you were a little toddler. Okay, this was your status. You were unable to manage property or business affairs because the individual has an impairment in the ability to receive and evaluate information or make or communicate decisions, even with the use of technological assistance. Okay, and then they got missing. Even if you're born, even if you're alive, even if you are able to do these things, you're missing. You're not there. Now I want to go to Black's Law Dictionary so I can show y'all what it says about the word incapacity. Here we go. A lack of physical or mental capacity, lack of ability to make certain legal consequences attached to one's actions. Example, a 5-year-old has the incapacity to make a binding contract. Okay? Disability, incompetency. Okay? That was your status after here in Georgia at 4 years, that was your status. Okay? That's where the power of attorney was put in place. It's put in place, okay? Even when you're missing, put in place. Okay, that's the status. That's your status in all those cases. Okay. I forgot to show y'all about the incapacity right here. This is the 1933 Black's Law Dictionary. The first one I showed y'all was 2009 Black's Law Dictionary. Okay, one of capacity, one of power or ability to take or dispose, one of legal ability to act. Now, scroll down to the bottom. This is the part I really want to show y'all right here. Okay, this expression implies that the person in view has the right vested in him, but is prevented by some impediment from exercising it, as in the case of minors. Females covert. That's a covered woman, like a woman when it comes to a woman with property rights. That's I think it's a Latin term. Lunatics, etc. Right here, an administrator has no right until letters are issued to him. Okay, so notice this is the part I wanted. That's why I highlighted letters of administration in that code about the presumption of death. And when letters of administration and letters of testamentary are mentioned, keep in mind the definition of an administrator. When it comes to this stuff, an administrator is someone who administers the estate of a deceased person. Okay, so he has no right. Administrator has no right until letters are issued to him. So once letters of administration are issued to him,
that's when he's actually able to invoke a general power of attorney. Now, let's continue.
Now, person means an individual, corporation, best business trust, estate, trust, partnership, LLC, association, joint venture, public corporation, government or governmental subdivision. Them the courts right there. Them the courts, the police station, the sheriff department, the child support agencies, the banks, all these jokers, these are all subdivisions. Government is, anyway, agency or instrumentality or any other legal or commercial entity. See, a person could be anybody right there. Or any of these right here, okay? Including individual, okay? Power of attorney means a writing or other record that grants authority to a person to act in the place of an individual, whether or not such term is used. Now, keep in mind, there are power of attorneys that were put in place before you were born. Okay? Your father and mother, your great-grandfather and mother. This stuff was going on for a minute now. So they've been doing this stuff for a long time. And if these things never got revoked. They never got revoked. They remained in place, and I'll show y'all that. Okay? And they will even put, well, I'll show y'all that. Okay, presently exercisable power of attorney, power of appointment with respect to the property or property interest subject to the power of appointment means a power exercisable at the time in question to vest absolute ownership in the principal individually, the principal's estate, the principal's creditors, or the creditors the creditors of the principal's estate. Such term shall include the power of appointment not exercisable until the occurrence of a specific event, somebody else's birth, the satisfaction of an ascertainable standard, or the passage of a specified period only after the occurrence of a specified event. The satisfaction of an ascertainable standard, or the passage of the specified period. Such terms shall not include the power exercisable in a fiduciary capacity or only by will. Principal means, this is where they use word salad also, means an individual who grants authority to a person to act in the place of an individual. Okay, keep in mind, this authority was passed down from generation to generation. So different people were able to grant these authority based on previous power of attorneys that were put in place. It didn't start with your birth. Okay, there were already power of attorney. Your parents has a power. If they have a power of attorney, if they're still alive, there's a power of attorney that's controlling their lives as well. Okay, and I'll show y'all all that. The effects of the power of attorney. I'll show y'all that in the next move, probably in the next spot. Let's see, property. Property means anything that may be subject to ownership, whether real or personal, or legal or equitable, or any interest or right therein, and shall include digital assets and electronic communications, as such terms are defined in code section 5313.2. Record means information that is inscribed on a tangible medium, or that is scored on in an electronic or other medium, and is retrievable in perceivable form. Let's see. Sign means when present intent to authenticate or adopt a record. Okay, to execute or adopt a tangible symbol. Okay. State means the state of the state of the United States. A state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory or insular possession subject to the jurisdiction of the United States. Okay, stocks and bonds means stocks, bonds, mutual funds, and all other types of securities and financial instruments whether held directly, indirectly, or in any other manner. Such terms shall not include commodity, future contracts, and call or put options on stocks or stocks indexes. Now, next we're going to the next slide now. Let me go right here. Done it already. I can close that. Here we go. This is where I went to. I'm going to show you when the thing goes in effect. Did I type in that part already? Let me see. I forgot to do that. Yes. Okay. When one goes in effect, it talks about right here. This is where it says authority of the agent. When they have the power of attorney put in place, they have authority to govern all these areas of your life. Okay, all these areas of your life. If you want to look this up and read all this on your own, do that at your leisure. But I'm specifically, I like talking about child support and stuff like that. So we're going to talk about personal and family maintenance. So I'm clicking on this. Unless a power of attorney otherwise provides language in the power of attorney granting general authority with respect to personal and family maintenance, shall authorize the agent to 1. Perform the acts necessary to maintain the customary standard of living of the principal's spouse, and the following individuals, whether living when the power of attorney is executed or later born. Did I not just say there was stuff done already before we got here? It was already put in place. So they're acting on. They continue this process throughout the generations. Okay. The principal's minor children. Okay. Let's see. Perform the acts necessary to maintain the customary living of the living customary. Perform acts necessary to maintain the customary standard of living of the principal's spouse, and the following individuals, whether living when the power of attorney is executed or later born: the principal's minor children, the principal's adult children who are pursuing post-secondary school education and are under the age of 25 years, the principal's parents, or the parents of the principal's spouse. That's your in-laws. If the principal had established a pattern of such payments or indicated a clear indication to make such payments. The principal's minor descendants who are not also the principal's children, if the principal had established a pattern of such payments or indicated a clear indication to make such payments. Them your step babies right there. If you're a stepdaddy, this you right here. If you're a stepdaddy, this you right here. Those are minor descendants because they're related to you by marriage. If you married a woman, her kids are your stepkids. That makes them minor descendants. And say who are not also the principal's children, because they're not your children, you're your stepkids. Okay? If the principal has established a pattern of such payments or indicated a clear indication to make such payments. So if you already taking care of that child, this is what they're talking about right there. And you go through a divorce and they try to make you pay child support for children that are not yours. That's it right here. Here you go. Principals of adult descendants who are under 25 years of age, not the principal's children, and pursuing post-secondary school education. If the principal had established a pattern of such payments or indicated a clear indication to make such payments. Y'all go through a divorce and they going through college, you still gonna pay for that shit. That's what they're trying to do. That's what the power of attorney gives them the power to make to act, the agent to act on your behalf. Any other individuals legally entitled to be supported by the principal. That's your babies right there, them your kids. Right here. Make periodic payments of child support. There we go. Y'all were looking for that, weren't you? Periodic payments of child support and and other family maintenance required by the court. That could be the daycare. It could be, playing school sports or whatever. They want to take up karate. Yeah, you got to pay for that if they want to put it in there. Or governmental agencies required by the court or governmental agency, or an agreement to which the principal is a party. Okay. Now, provide living quarters for the principals for the individual described in paragraph 1 of this subsection by purchase, lease, or other contract, or or paying the operating costs, including interest, amortization payments, repairs, improvements, and taxes for premises owned by the principal or occupied by other individuals. Well, what if it's occupied by your ex-wife? Yeah. Let's see. Number 4. Provide normal domestic help, usual vacations and travel expenses, and funds for shelter, clothing, food, appropriate education, including post-secondary and vocational education, and other current living expenses for individuals described in paragraph 1. Everybody up here at the top up here. Okay. Of this subsection to enable such individuals to maintain their customary standard of living. So if they were living like that before you go through a divorce, the agent can. That's why they're able to do that shit, is through the power of attorney. Okay, they doing it through the power of attorney when you go through a divorce. Now we're gonna get to the remedy if y'all keep on. So you stick with me. Okay. Let's see. I know I'm gonna trigger a lot of people watching this here, but I don't give a damn. This need to be out here. People need to know what the hell going on to them. What's going on with them? What's happening with their lives? Okay. Number 5. Pay expenses for necessary health care and custodial care on behalf of the individuals described in paragraph 1 of this subsection. Act as a principal's personal representative pursuant to Health Insurance Portability and Accountability Act, section 1171 through 1179 of the Social Security Act, 42 USC section 1320D, in effect on February the 1st, 2018, and applicable regulations in effect February the 1st, 2018, in making decisions related to past, present, and future payments for provision of health care consented to by the principal or anyone authorized under the laws of this state to consent to the health care on behalf of the principal. So you ain't got the damn consent, but they can do it on behalf of you. If you got you an attorney and you got you an attorney trying to tell you because you're going through a divorce and you wondering why the attorney still stuck a dick up in you, it's how you can do it, through the power of attorney. Okay. Continue any provision made by the principal for automobiles or other means of transportation, including registering, licensing, insuring, and replacing them for the individuals described in paragraph 1 of this subsection. Look at that. Maintain credit and debit accounts for the convenience of the individuals described in paragraph 1 of this subsection, and open new accounts. So this is why they're able to do what they want to do when they want to they go all in your bank account when you're saying you owe child support. Keep in mind they control that too up in here. Where that at? Where's that? Child support. And they all up in your bank account, maintaining your bank and your credit, your account. It's through the power of attorney. Continue payments. Now keep in mind, I'm gonna wait till I finish this first. I ain't got but one more. Continue payments incidental to the membership or affiliation of the principal in a religious institution, club, society, or order or other organization to continue contributions to those organizations. B. Authority with respect to personal and family maintenance shall be neither dependent upon nor limited by authority that the agent may or may not have with respect to gifts under this chapter. Okay, as you see, this is what they all can do with it. This is what the authority of the agent. This is what they're able to do when it comes to personal and family maintenance with a power of attorney. Okay, here in Georgia. I like how they word stuff here in Georgia. It's so easy. It's easy to pick up to pick up on what they're saying. Okay. Now, let's get to the remedy. Let me see. Here we go. I think that's what I was going to anyway. Yeah, that was it. That was it. Let me see. Yep, that's it. I'm gonna go to the remedy now. Okay, a power of attorney shall terminate when the principal dies. That's one. The principal becomes incapacitated if the power of attorney specifically provides that it is not durable. The principal revokes the power of attorney. Bam, there go your remedy. The principal revokes the agent's authority, or the agent resigns, becomes incapacitated, or dies, and the power of attorney does not provide for another agent to act under such power of attorney. Number 5, the power of attorney provides that it terminates, or the purpose of the power of attorney is accomplished. Okay, there's your remedy right here. Let's keep moving. B, a power. Let's see. An agent's authority shall terminate when the agent resigns, becomes incapacitated, or dies. The principal revokes the agent's authority. Okay. Let's see. An action is filed for the dissolution or annulment of the agent's marriage to the principal, or their legal separation, unless the power of attorney otherwise provides, or the power of attorney terminates. The power of attorney terminates, and it tells you the power of attorney terminates when you revoke it. So when you revoke it, the agent's authority also terminates. Okay, it says that. I didn't say it. You see it for yourself, right here. As you see right here, you can actually let's see. Y'all see that this talking about two people being married right here. An action is filed for the dissolution or annulment of an agent's marriage to a principal. That's the agent and a principal. That's a husband and wife, or their legal separation, unless the power of attorney otherwise provides. But bottom line is, if there's a power of attorney, you can revoke that damn thing. Okay, you can revoke it. So even if your spouse has a power of attorney, you can actually revoke the power of attorney that even your spouse has. Nobody has the power to just run your life like that. You have to revoke it. Okay, let's keep going. This is one of the reasons why people not knowing this, though. One of the main reasons guys don't want to get married, because they don't know nothing about this. Okay, here we go. Because they don't want the courts running their lives like that. Unless the power of attorney otherwise provides, an agent's authority is exercisable until the authority terminates under subsection B, which is what we just read of this code, notwithstanding the lapse of time since the execution of the power of attorney. Termination of the agent's authority or the power of attorney shall not be effective as to the agent or another person that without actual knowledge of the termination acts in good faith under the power of attorney. Remember, you have to make sure they know. Without actual knowledge of the termination, you have to put them on notice. Okay, that you're gonna do it with a revocation of power of attorney. Any act so performed, unless otherwise invalid, unenforceable, shall bind the principal and the principal's successor in interest. Incapacity of the principal of a power of attorney that is not durable shall not revoke or terminate the power of attorney as to the agent or other person without actual knowledge of the incapacity. Acts in good faith under the power of attorney. An act so performed, unless otherwise invalid or unenforceable, shall bind the principal and the principal's successors in interest. So you're just letting you know, you have to put them on notice. Okay, if you you can't just revoke it and they don't even know you revoked it. So if somebody's still acting as if if you got an attorney, you got a court case, and you want to fire his ass, he has power of attorney, you got to give him notice. You got to give him notice. It needs to be in writing. Put that notice, put it in writing, and you got to serve it to him to let him know that his services are no longer needed. At that point, his powers are terminated. Okay, we're gonna move forward. Here we go. The execution of a power of attorney shall not revoke the power of attorney previously executed by the principal unless the subsequent power of attorney provides that the previous power of attorney shall be revoked, or that all other powers of attorney are revoked. So if you just creating a power of attorney and there are other power of attorneys already out there, this power of attorney is not going to revoke these power of attorneys unless the subsequent power of attorney provides that the previous power of attorneys shall be revoked. So you can mention in your new power of attorney that all previous powers of attorney are revoked. Okay, that's what revokes the rest of them. If you mention it in your new power of attorney, okay, say that all other powers of attorney are revoked. You got to mention that in your new power of attorney in order to revoke the old ones. If you don't mention it in the new ones, then the old ones stay in effect. That's what this is saying. G, nothing in this code shall prevent the principal. That's you. Nothing in this section shall prevent the principal who notifies the agent of the revocation of the agent's authority or power of attorney be certified by let's see. I'm gonna start over. Nothing in this code shall prevent the principal who notifies the agent of the revocation of the agent's authority or power of attorney by certified mail or statutory overnight delivery from filing such notification and evidence of its receipt by the agent to the clerk of superior court in the county of which the principal domicile, for the purpose of establishing such agent had knowledge of the principal's revocation. That's proof that you actually. They can't say they didn't get it. They can't say you didn't revoke it if you got it. You sent it to them certified mail or statutory overnight delivery, revocation of power of attorney. You giving them notification that they've been revoked. Their powers have been revoked. Notifies the agent of revocation. That's a revocation of power of attorney notification. You gotta serve them, and when you serve them, you send it to them certified mail or overnight statutory delivery. That's what it says. And then when you get that, it say from filing such notification. That's your original. And evidence of its receipts. That's the green card of its receipts by the agent. Okay, you received it. They received it. The agent received it. They signed the document. They signed it proving that they received it. So once they receive it, you get the green card back. You take the notification and the evidence, which are the green cards, and you file it. You file it right here. File such notification with the clerk of superior court of the principal's domicile for the purpose of establishing such agent had knowledge of the principal's revocation. That's proof that you served them. Now you can get a certified copy of this record, of this filing, of that whole filing. You can get a certified copy of that filing and use it to prove that you revoked their power. They can't move after that. Okay. So that's your remedy to terminate these powers of attorney that they got. Everything that they've been controlling all this time, all your life, you take control of that back. Okay? And I believe this works with these agencies, because keep in mind, it makes me wonder, why do I have to use, like, you got a Social Security account. You have interest in that name. Regardless, the number's not yours, the card ain't yours, but the account is in your name and you got interest in it. Because the original name came from you. That straw man name derived from your given name that your father and mother came, and they have securities attached to it. You have interest on that. So it makes me wonder, why do we have to use that? Why we got to go through a third party and apply for something for them to use the credits, and then they go and lend you credit from your own account, and then pretend like they loaned you something when they never loaned you shit. So it makes me wonder, power of attorney. That gives them power to be able to do these types of things. You know what I'm saying? Just like people are rescinding their car contracts. Their car contracts. Their first one of the part of the process is using a revocation of a power of attorney. That's part of the process. Not the whole process, but it's part of the process. But I'm not getting on that right now. But this is what I'm talking about. Them powers of attorneys are something else they're using to control your lives. You gotta take your power back and get on top of it by revoking this stuff yourself, revoking it and follow the instructions. Okay? I'm gonna get out of here. I thought I'd make this video. I think this thing that helped y'all. This is probably the most powerful video I have created all year. It may be the most powerful one because it's got my wheels turning. Y'all see how fast I'm talking. It's got my wheels turning and I ain't had no sleep. I had very little sleep and I was amped up all night last night. I actually made this video before, but I had to go do another version because I don't like how I was missing a lot of stuff, probably because I was still just now learning it. And I've been talking about this all day today, which caused me to more wheels to turn, and it just becomes more and more clearer as you continue to talk about it. And I've been talking about it all day to other people on the phone that I talk to on a regular basis. And so I can explain it a hell of a lot clearer than I did the first video, so I won't be posting that whole video. But this, you got it. Hopefully y'all have already liked and subscribed. Let's see what else. Let's see. I don't know. I guess I'll see y'all in the next video. I think this video is long enough, and hopefully this information helped you. If you need to reach out to me, you can reach me at dunamismichaels@gmail.com. That's dunamismichaels@gmail.com. That's DUNAMIS MICHAELS. That's dunamismichaels@gmail.com. And we can if you got any comments, hit me in the comment section. I'll see y'all then, and if I gotta make a video to answer you, I'll do that. And we'll get it popping, y'all. Let's get free. All right, y'all. Emeralds signing out.
Man, this shit got me where I can't even sleep. Think about this. When there's a presumption of death that is established, a presumption of your death, just keep in mind, if you look at the definition of a power of attorney, it shows you that a power of attorney has to be created by a natural person. That's the commercial term for it. They call it a natural person, which is talking about a living being. A straw man can do no thing. Okay? The straw man can't act on his own, so it has to have somebody there in order to move on his behalf. So since you have not come forward and rebutted the presumption of death, they got somebody else acting. The courts will grant someone, place an agent there to operate. Depend on what's to be done to operate as the power of attorney. They'll grant them the powers of attorney to move on your behalf. That's something else. That's crazy, ain't it? Because there's a presumption of your death because you haven't come forward and taken control of the name. You haven't done anything. And the Cestui Que Vie Act of 1666, after 7 years, it's 4 years here in Georgia. I think it's 5 years in Florida. It's different in different states. California is 7 years. Based on the Cestui Que Vie Act of 1666, you're presumed dead. That's when they place the power of attorney. They start granting the public officials or whoever to become the agent as power of attorney to operate on your behalf. And it's written right there in the codes. And we're talking, it covered every damn thing. It covered everything. They have power to do all this stuff. And you have to revoke that power of attorney in order to gain control of your state to be able to move on. That is something else. I don't know why I didn't think of that before. It's on and popping now. Ambrose signing out.